All right. Please proceed, Mr. Wardell.
Actually, I'm the appellant.
The other way. Okay. Well,
Yeah.
I looked at the.
Thank you. That's no problem. I'm Brandon Wesley.
Yes.
I'm from the Florida appellate firm. I represent Rudolph, Wesley, and the Executive Mortgage and Investment, Inc. I'd like to reserve 5 minutes for rebuttal.
All right. You got it.
May it please the court. This case involves a non-arm's length transaction whereby Curtis Davis, the vice president of executive, deeded over a valuable piece of property to his college friend. Mr. Deloit, which is his friend, had a second mortgage on the property. And yes, Mr. Deloit paid off the first mortgage on the property when it was going into foreclosure. But Curtis Davis, who subsequently went to prison and was defaulted in this case, had no authority to offer a deed in lieu to his college buddy.
Isn't that a factual issue?
Sorry?
Isn't that a factual issue?
Did he have authority?
Whether or not there was sufficient authority, or whether an agent bears authority to act on behalf of a corporation?
It would be a factual issue, Your Honor. However, there's no evidence in this case at all.
Wasn't there a request for admissions that he was the vice president?
Well, Your Honor, being a vice president doesn't automatically give you authority to deed property over. That's the statutes that we're going to talk about. There's 3 of them. And the first statute, 692.01.
I understand the statute, to pick up where Judge Lucas left off. I understand that statute, when the statute that mentions that particular officer includes additional requirements. But under 689.01, to ask Judge Lucas's question a different way, how is a court, let's say that we weren't operating at all under 692.01 or 692.102. Let's say opposing counsel never even mentioned them and just said, we're operating under 689.01. How does a court determine whether a lawfully authorized agent conveyed the property? How do they do that? How do you establish that?
Evidence, Your Honor. They have to present evidence at the hearing, and there was no evidence presented on their side. Like I said, Mr. Davis was defaulted, and all of the evidence.
So you would concede that even though one of the other statutes mentions the vice president and includes additional requirements, that doesn't foreclose the possibility that under 689.01 in isolation, a vice president could be a legally authorized agent of a corporation, right?
If he had a corporate resolution or he had authority from the president, but in this case, the evidence was crystal clear that he didn't have that authority.
What about the evidence that from the president that said, well, he was running things at the time?
That doesn't give him authority to transfer property, Your Honor. He has to have authority. If you look at the case that the George versus Miller Bay paralegal, that case from this court, Judge Valenti's opinion, the same situation occurred there. There was no evidence to show that the person had authority. It was all one-sided, and that's exactly what happened in this case, Your Honor.
Well, help me out too. Like, this was basically a deed in lieu of foreclosure, right?
That's correct.
Were there substantive defenses to I'm saying this wrong, I'm sure, Deloit's foreclosure? I mean, what was the corporation going to defend on when its president was basically out of the picture? Did it have any other? I mean, is there any evidence that it had any other assets, that it had any defenses to this? I mean, what?
Well, there was not clear evidence he was completely out of the picture, Your Honor. He did say that Mr. Davis was running things, but at the same time, what you're talking about, he actually, Mr. Deloit, he paid off the mortgage that was in foreclosure. So then he assumed that claim. I guess he could have brought that claim, but it never happened because almost immediately this deed in lieu of was given. But you know, the property had value, and obviously there's deed in lieu. Deed in lieu is to avoid having, you know, generally, I mean, just generally speaking, it's avoid having an upside down property, you know, to go through the process. But we wouldn't be here if that was the situation. Anyway,
not always.
So Your Honor, let's talk about those requirements and the authorization that is needed if you're going to rely on 689.01. He did have the presence of 2 witnesses. and he did sign it, but he needed authorization. And the evidence in this case, not only is the evidence my client's testimony that he clearly did not have authority to do this, but there's also evidence in this case that every other deal that Mr. Deloit did with executive, and they had done several over the years, every other deal and every other instrument that needed to be signed was not only signed by Mr. Davis, but was also signed by Mr. Wesley.
Right. And Mr. Wesley, I appreciate you bringing all this up, and I'm glad we're getting down to brass tacks of your argument, which is basically the trial court got it wrong on the facts. But this comes to us after a trial, right? So help me out with that. You know, you're saying that basically that there was the trial court could not have entered this judgment based upon the facts before it. You've done a lot of appeals. You know that's a high standard. So
absolutely,
help me with that high standard.
I want you to look at the fact that this trial occurred in November of 2022, and this judgment didn't come out until July of 2023. So we're talking there's a 7-month period in there where we don't know what's going on. The parties were submitting findings of fact, conclusions of law, and there's, we don't know what happened at that point. But what we do know is at trial, this particular judge honed in on George versus Miller Bay and talked about it and specifically pointed out the exact same argument that we're making and used that argument to deny a directed verdict.
You're saying the elapsation of time might have contributed to the trial court's changed thinking on whether George Anderson controlled, but the elapse, how can we, but it's still a fact issue, right?
And then the greater part of the argument is, Your Honor, he applied Prezesio versus Cameron out of the fourth that predated our George versus Miller Bay decision by 31 years, and it's the wrong district. He's applying that case. And then if you look at that case and you look at we did a request.
Applying a different statute, you're saying too, right?
He applied a different statute. He was applying 92. He wasn't even applying.
Well, I'm saying that case cites that relies on a different statute. I can't pronounce it either, but anyway.
Prezioso focused on 689.01. And Prezioso, like I said, 4th DCA, 31 years before Miller Bay, the George versus Miller Bay, and Judge Valenti's opinion in that case. In Prezioso, the court talked about, sort of in generic terms, that the vice president would have authority, president, vice president, CEO would have authority to do this with 2 signatures. But what you didn't hear, and what was not included in the opinion, was that they actually had a seal on the deed that they're talking about. And we found that, and we asked the court to take judicial notice of that public record. There was a seal, a corporate seal on that deed. So it really, unfortunately, I think the court got it right, maybe in Prezioso, but only from the standpoint that there is actually a corporate seal on that deed. Otherwise, they're dicta, if you will, because I don't even think they relied on that particular issue to make that ruling. I think it was more like dicta. I think that, the court should look past it as being incorrect. So, it's clear the court was aware of this court's decision in George Anderson training. 7 months passed, memories faded. I don't know what happened. Nobody knows. You can only speculate. But I think it's obvious that the court recognized what we're arguing now, and what we're arguing now is the statutory law requires a vice president to either have a seal or have some authority, corporate resolution or something. If you look at
the problem with that argument,
is that a correct statement? Sorry, Judge Lucas, go ahead.
Oh, I was just going to ask, just real quick, the problem with at least the first part of that argument is that the statute that they're traveling under expressly states no seal shall be necessary. I mean, again, I'm talking about 689.01. No seal shall be necessary to give validity to any instrument executed in conformity with this section. So how can you read back in? Look, they can either get an official authorization or they can get a seal when the statute says they don't need a seal.
Well, again, Your Honor, they have to have authority.
Right.
It'd be corporate resolution, or the president could have done it like he did with these other instruments with Mr. Deloit's animal genetics company. they have to have some authority, and he did not have authority in this case. The evidence is clear he did not have authority. So you're asking the court why, you're asking me why why can't he do it under 689.01? You can imagine if a corporation, and lots of corporations have multiple vice presidents, if they can just go out and sign over deeds and those deeds stand, it's going to put this is what they're trying to avoid here. They have to have some corporate resolution, some authority given to them to make this deed. And if you look at 692.02, which we cited in our brief as well, that one talks about how if a vice president has a seal on the deed, it should be considered valid. Now, why would they need that? They wouldn't need that at all if they could just willy-nilly sign over deeds because they're a vice president. I mean, the president.
Not because he's the vice president, because he's an authorized agent.
You would not even need these other statutes, Your Honor. You wouldn't need any of this because then you wouldn't need a corporate seal.
Well, doesn't 689.01 say you don't need those other statutes? It says you can go under this statute or the other statutes.
That's correct. But you have to have authority. And you're assuming he has authority to deed property when there's nothing in the record to suggest.
Well, let me ask you this. You keep saying there's nothing in the record, and isn't that you've distinguished Prezalewski, or I forget the name, but but isn't George Anderson distinguishable in that there was the evidence against authorization was unrebutted, whereas here, yes, Mr. Wesley provided some evidence of lack of authority, but it was not unrebutted.
It was
also evidence of authority. Even if you say, sort of eliminate the course of dealings type of argument about the past conveyances, because as you said, they included the president on them up until this one conveyance. But isn't there other evidence? I'm sure Mr. Wardell is going to talk about it. You might want to talk about what evidence he's going to say rebuts Mr. Wesley's evidence of lack of authority.
So let me just set the record straight here. There was an issue in this case early on. Was he even a vice president? Was he just a CFO? And of course, none of these statutes talk about CFOs. So the issue that they honed in on initially was he's not even a vice president. And so there was a lot of back and forth on, is he a vice president or not? That's where all this information came in. It wasn't whether he had authority. It was whether he's a vice president. And we're conceding that he was a vice president. But we're saying just because you're a vice president doesn't mean you have authority. You have to have some kind of authority. And this case was devoid of that. They could have gone and got a deposition from the man in prison. They could have presented evidence that showed that. There's nothing. They had one witness, Mr. Deloit, and he came in and he said, well, I assumed he had authority. That's not evidence.
Didn't Davis file a corporate amendment?
Sorry?
Did Mr. Davis file a corporate amendment making himself a vice president?
Yes, he filed his own corporate amendment making himself a vice president.
And Wesley didn't know about that, but the judge found something in his final judgment saying, so what? It still was valid. Is that correct?
Yes, because I guess anybody in the corporation can fill out that form and say who's who.
Well, he compared signatures.
Sure, but we're not disputing that he's a vice president.
I mean, you did a motion for rehearing and it was denied, pretty basic. Was there a hearing on the motion for rehearing, or it was denied without a hearing?
It was denied without a hearing, Your Honor.
So you have no way to know what the judge was thinking because the denial doesn't tell us a whole lot.
Right.
Okay, gotcha.
Yeah, Your Honor. So my argument is, if this court is going to rule in their favor, they have to take the evidence that's been presented, the limited evidence that's been presented, including my client's testimony, no authority, all of these documents that have been signed by both Mr. Davis and Mr. Wesley that are within the Deloit collection, and then turn around and say he had authority just because he's a vice president. That's not what the statute says. You can't, just because you're a vice president doesn't mean you have authority. And there wouldn't be any need for these other statutes if you had that kind of a case. So anyway, so they're also going to argue that that it's not that Mr. Decolet's statement that he thought he had authority is sufficient, and that doesn't work with the statute. That's not a proper analysis.
You're down to your 5 minutes. Did you want to save that for rebuttal?
I'll just finish it real quick here. It's
All
not
right.
a proper analysis on the statutes, and it must be noted that all of these other documents said otherwise. Okay, I'll reserve the rest of my time.
I'll give you the 5 minutes.
Thank you.
All right. Appellee, Mr. Wardell.
Thank you, judges, and good morning. I'm James Wardell on behalf, and I don't know if I'm saying this right either, but I've always said Deloit, and I'll refer to him as Mr. Deloit. Judge, in this case, what the court did was it took a plain and just reading of a statute and led to a plain and just result in this case.
You said the court did that. How do you know the court did it the way you're saying it?
Well, that's what the court said that it did in its actual order. The court did make findings, and the court determined based on the evidence. And it was interesting because the court used mostly Mr. Wesley's testimony, and he put that in the order. And then he also referenced the admission that, they originally proceeded under this case under some theory that he wasn't a vice president. But then the facts were overwhelming, and they had to admit that he was a vice president. And then they tried to kind of change their argument. So the court went through all of that in its factual findings, and it ultimately made the findings at number 12 and number 13 of its order that the court finds that Mr. Wesley appointed Mr. Davis to serve as vice president of executive in 2002. And the court did ask earlier, Judge Valenti, you did, about whether the vice president presented some stuff himself or filed some documents himself. Well, the court found that it was Mr. Wesley that signed that amendment, and he made that factual finding in his order. So he determined that Mr. Wesley's testimony, without saying it, was disingenuous, but he said it didn't matter because they ended up admitting it later, that he was in fact the vice president. The second finding of fact was that the court finds that Mr. Davis acted as vice president of executive from his appointment in 2002 through the execution of the subject deed in 2014, and that he did so at all times with the knowledge and consent of Mr. Wesley. And that raises some points, some other factual points that some of the other justices brought up, was that Mr. Wesley was nowhere to be found during the time frame. This was signed in 2014, and he didn't even raise an objection to it till 4 years later, because he was not active in the business at all. He left it all to Mr. Davis to wind down the business. And when I say it was a just result, this is not something where Mr. Wesley's suggesting that this is his college buddy or something. He had Mr. Deloit paid. He made a loan that is not disputed, that was recorded, was a second mortgage, and then that second mortgage wasn't paid, and then the first mortgage wasn't paid. So Mr. Deloit, in order to protect his position, had to pay off the first mortgage. So it's just in the sense that he paid for all of this, and none of that's in dispute in this case at all. So when we say the court did a very good job of making factual applications and applied the statute, which is 689.01, it specifically says you don't need a seal, and the court made factual determinations that Mr. Davis had the authority as vice president to convey this property. If you do look at it in conjunction with some of the other statutes, 692.01 and 02, which you don't have to, but if you do, I think it helps our position even more, because under those facts, it basically sets out that a vice president does have the authority to do this. And it looks from the perspective of the person that was the beneficiary in this case, which is also, that's Mr. Deloit, and he had the ability from his perspective to be able to rely.
Are you saying the court could make that finding without a copy of a corporate resolution, or the testimony that a corporate resolution occurred to give him that authority?
Well, Judge, I think he could. I don't know that there's any requirement that a corporate resolution would have had that, but he cites the Prezioso decision. And again, I'm probably saying that wrong too, but I know everybody, since we all got it wrong, I feel better about it. And the bottom of that case, it says the court noted that the practical purposes of section 692.01 is to allow third parties who transact business with corporations in an honest fashion to have confidence that the transactions are valid. We agree, as this section indicates, the officers of a corporation are vested with apparent authority to conduct the corporation's business. Absent fraud on her part, a party doing business with a corporation is permitted to rely on the officer's status within the corporation as sufficient power to bind the corporation in the execution of mortgage instruments, which is exactly what we have here. Now, the Miller Bay decision, Your Honor, which I know, Judge Valenti, you authored, it's completely factually different. I mean, to have that was basically a woman committing fraud at like 3 different levels on 3 different deeds for something that she was taking the money for, that's selling a property that she didn't own. So under those facts, completely distinguishable from this particular case, where a just application of a plain reading of the statute results in a just decision. In that case, based on those facts, the lady was never even the president. So, and nothing was contested. She didn't show up or respond or anything like that. So it wasn't a situation where a court had a trial where the judge made factual determinations and actually used the testimony of Mr. Wesley to come to the conclusion that Mr. Davis had authority and there was no fraud anywhere, and that Mr. Deloit had the ability to rely on him as a vice president.
Wasn't there also evidence in at trial that that Mr. Wesley was aware and on board with the underlying loan itself of Deloit and taking over the first mortgage? That he knew all about that and had a discussion with Mr. Deloit?
Well, there was, I believe there was some testimony to that effect, but he was no longer involved in it. It acknowledged that the first mortgage wasn't paid and a foreclosure action had been filed, and that Mr.
But what I'm saying is that he did know about the underlying transaction itself. I mean, he admitted it in his testimony.
He did, yes, Your Honor. So
and that Mr. Davis was part of this, this deal, which it sounds like it's kind of like a deal-centric kind of business, right? Because Davis gets brought on board as a loan, I guess, like a loan officer. He's maybe got a stake in like an ownership interest in the company, and it's kind of like they just do these various deals together. So at least until it's unrebutted that at least up until the deed in lieu of foreclosure, which is what I'm calling it for shorthand, he knew about the Deloit taking over the unpaid first mortgage and his subsequent interest in the West Shore property.
I mean, I know that he was on all the documents in the original foreclosure action that was filed that Mr. Deloit had to settle by paying off the first mortgage. So I think it's definitely can be inferred from the record that he had knowledge of that. If I don't specifically remember if he admitted that, but he probably did. But there's no question he knew about it, and all of this from the timing was, he left. Mr. Wesley left all the business because everything was upside down at the time after the 2008 property crash when Mr. Davis was the only one managing, kind of winding down this business at the time. So I think that all of that goes to kind of the factual findings of why the application that Judge Nash did such a detailed, wrote an order and put these factual findings in and relied on that. And what Mr. Wesley said about, we don't know why he changed his mind and maybe you forgot. Well, that's not the case at all. I mean, that was a motion for summary judgment, and he was just, we had a trial after that. And he didn't issue the order right away after the trial, but the summary judgment, when he was, allowed them to go forward to trial, that's when he basically cited to the Miller Bay case and asked some questions about it. But after hearing all the facts of this case, he decided otherwise, and he wrote all of that in an order. So I don't think that's any indication that perhaps he forgot or got confused somehow. I think he did exactly what was right based on the facts and the conclusions of law. And he relied on 689.01, which I think is absolutely correct. There's there's no requirement anywhere that you know, they're doing such a narrow reading, trying to say that a person with authority has to be some authority that's granted in writing. It doesn't say that anywhere. And if you certainly look at it from Mr. Deloit's perspective, there was no reason not to believe that the deed in lieu of foreclosure for the property he already paid for by paying off both of the mortgages wasn't valid, and Mr. Davis had the authority to do it because he was the only one running the company at the time, which is a factual finding by the judge, based on the testimony of Mr. Wesley. So
That it?
Your Honor, that is it. Thank you.
Thank you very much.
Oh, I'm sorry, Judge, if I can take that back. I did file a notice of supplemental authority for the DGG Corp versus the estate of Capone, and that is at 983 Southern 2nd, 1232. And that case is very factually similar to this particular case. And in that case, it says the corporate seal was not affixed to the deed, but it was executed in the presence of two witnesses and a notary public, which is what we have in this particular case. And then after the corporate resolution was reinstated, the decedent and the wife conveyed the property to the decedent and the guarantees. The appellate court noted that under 689.01 and 692.01, if the person executing a deed not under seal was not the corporation's president, vice president, or chief executive officer, an authorizing resolution from the board of directors had to be obtained. So basically, in that case, they overturned the decision because the conveyance of that particular interest was done by a secretary as opposed to a president, vice president, or chief executive officer. So it basically was saying what happened in this case was the right way to do it, and that a vice president does have the authority to convey a deed, and that's consistent, of course, with Prezioso, which is the intent of allowing people to rely on that. Thank you, Judge.
All right, thank you. Mr. Wesley, you asked for 5 minutes rebuttal. I saved you 5 minutes.
Thank you, Your Honor. You know, what they're advocating here is that any vice president, under any circumstance, if he can get two witnesses and a notary, can deed away property without any problem.
Can you explain away the case he just cited in his supplemental authority?
Yes, I can, Your Honor, because they just got it wrong. It's a 5th DCA case. There was dicta. It says similarly, if a deed is executed, and they're giving like an example, and they got it wrong. This is not what 689.01 says. It says you have to have authority, and the authority is important because any vice president and any CEO and any president could just, well, the president, I always.
Well, here's my question. The facts of this case were the vice president made himself vice president. There's no objection. He ran the company. For how long did he run it? And he had to do day-to-day activities. That's basically the testimony. True or false?
Absolutely. Vice presidents do day-to-day activities all the time, Judge, but they don't deed away property that belongs to the corporation. This is a piece of property that had value. And the fact of the matter is, you know, if this had gone through on a foreclosure, it would have gone to sale, and then our argument would be that there's going to be some money at the other end of it for the corporation. Maybe.
Yeah. No, I understand your argument.
So that's the point. That's the point we're trying to make. Prezioso, 692.01, it requires a seal. Prezioso is relying on 692.01, and it talks about how the vice president has all this authority. If he has a seal, he has to have the corporate seal. You know, obviously, if you give Mr. Davis the corporate seal, he has the authority to do it. But if he doesn't have the corporate seal, you got to read your own words in George versus Miller Bay, because it's right on point. And it is not. They didn't talk about the fraud. They talked about 689. They talked about 689.01, and it talks about how there was no evidence to show that this person had authority, and without some evidence to show he had authority, then he couldn't do it. He couldn't transfer it away. He needed authority. So, Your Honors, you know, if this were a similar case and this property was worth, you know, $10 million and the mortgage was only $1 million, and this person signed it away, you could see the injustice there. And I'm not saying that's the case. We don't have those facts, but I'm saying you can see why this is important. You can see why the statutes require a vice president to actually have authority to be signing away deeds from property. And, you know, I get it. Mr. Deloit put a lot of money into this because he had the first mortgage, the second mortgage. I get it. He's entitled to be paid, but he's not entitled to get a windfall. And that's where we're at. I know it's not fraud. We're not saying it's fraud. I'm saying that this person didn't have authority to do what he did. Let's undo it. Let's let Mr. Deloit, you know, either foreclose or get reimbursed by getting a second, you know, a third party financing or something. But, you know, this is not.
What of the fact, I don't know if the trial court made much of this, but what of the fact that there was some testimony that he not only was vice president, but a 15% owner of the company? I mean, isn't that also a fact that could imply that he had some kind of agency?
Well, 15% is less than 50%. So, I mean, obviously, but
work with me on my term, on the terms of my question.
15%, you know.
It isn't 50,
what if you're vice
but he's an
president,
owner.
What if you're vice president at Amazon and you have 1% of the company and you did sign away the deed to their you know, their corporate headquarters? Is that going to be enforceable?
I might be liable in fraud for a whole bunch of money for having done so.
You got about a minute to.
They didn't have authority.
Call my corporate D&O carrier. You know, I mean,
I guess your honors, this case boils down to a very simple proposition. Does a vice president, absent some kind of written authority or some kind of clear indication from the president, get to deed away property? And these statutes talk to that. 692.01 specifically says, oh, he can do that, and it's going to be enforceable as long as it's got a seal on it. 692.02 says that. 692.01 says, hey, president, vice president, CEO can transfer as long as they have a seal. So, and then 689.01 says, well, if they have authority and they get the two witnesses and they get the notary, then they can do it as well.
Mr. Wesley, you did a fine job, but you're out of time now.
Thank you, your honors.
I want to thank you both for a great presentation, and we'll be adjourned. Thank you very much.
Appreciate it.
Thank you, Judge.